I have the distinct honor of introducing one of our former graduates from the University of Houston Law Center, Dr. Philip Zelikow, who is the White Burke Miller Professor of History at the University of Virginia, has been a professor before at Harvard University, and was the executive director of the National Commission on Terrorist Attacks upon the United States, the 9/11 Commission, and was later a counselor of the Department of State when Secretary Rice was the Secretary of State. He also currently advises the Global Development Program of the Bill and Melinda Gates Foundation and is a consultant to the Office of the Secretary of Defense. He received his JD at the University of Houston and a PhD and an MA at Tufts University, the Fletcher School of Law and Diplomacy. Dr. Zelikow.
It's good to be here this morning. It's good to be back in Houston. I'm grateful for the Houston Law Review for organizing this symposium and bringing two really genuinely prestigious commentators to Houston to talk about these difficult and somber issues. Not the kind of issues I'd prefer to talk about on a beautiful autumn morning, one of the rare, cool, sunny mornings that you get in Houston in the fall. But that is an appropriate subject for us today. The United States has been waging a worldwide armed conflict against al-Qaeda and its allies for more than 10 years. The issues that I want to focus on today are the codes of conduct that the United States has improvised, and it's important to stress that term improvised, during the last 10 years of what I've termed a Twilight War. I'll focus only on two major issues. The first are the codes for questioning enemy captives, and the second are the codes we use to define who is the enemy. I want to offer a quick preface. I've served in various government positions over the last 10 years. I was a member of the President's Foreign Intelligence Advisory Board for Bush 43 from 2001 to 2003. I directed the 9/11 Commission in 03 and 04. I was the counselor of the Department of State. That's not the legal advisor's job. It's a kind of deputy to the Secretary of State. In my case, responsible for all the intelligence and terrorism-related issues, among other things, that came to the State Department between about 2005 and 2007. And I'm currently a member, again, of the President's Intelligence Advisory Board, now for President Obama. I want to stress that nothing I'm going to say today draws on any information that is currently classified national security information of the United States government. But a lot of stuff is public and is available. A lot of material has been declassified. The two issues I wanted to discuss were, first, questioning enemy captives. Let me focus on that one right now. I want to break this down into parts and be analytical about it. First, let's set the scene in which these decisions were made. These decisions were made principally, I believe, in the winter and spring of 2001-2002. I believe they were made between about November, December 2001 and about April 2002. That 6-month period is, I believe, the formative period for these policies. While we know quite a bit about the content of the decisions made about how to interrogate enemy captives, we know surprisingly little about how these decisions were made. That's actually what interests me the most, is exactly what happened and why. I'm not so much interested because I want to hand down judgment on it one way or another. I'm not here as a prosecutor or a defense lawyer. I do, however, want to understand these decisions because they're important. Questioning enemy captives in this kind of conflict is one of the most important ways you gather intelligence. It turned out to be one of the signature ways the whole legal regime in the war on terror was conducted and had dramatic effects on the way the world perceived the United States and the views of the legal community. But it's important also for one of the things we should learn about the way we handle difficult issues as a people during times of crisis. And if we can understand things that seem, I think will increasingly in retrospect seem harder and harder to understand, that will be important. It's important, for example, we look back on World War II. We try to understand why did the United States of America intern more than 100,000 Japanese Americans in concentration camps at the outset of the war. I mean, we know it happened. Well, why would the Roosevelt administration do that? And you say, well, wartime hysteria. That's not a good enough answer. You want to get into more detail about how exactly that decision was made in order to comprehend what would later seem incomprehensible. And I think that's going to be important here too. The final reason this is puzzling, and this is one thing I want to stress, as a veteran bureaucrat at times, although I now teach history and I'm the dean of a graduate school at the University of Virginia, the Graduate School of Arts and Sciences, it's important to stress how bureaucratically odd this decision was, the interrogation decisions. Of course, it's unprecedented on a moral and legal level for the top leaders of the United States of America to coolly and in a calculated way devise procedures for tormenting enemy captives is something that America's leaders had never done before in any national crisis. We had interrogated high-value enemy captives numerous times before, but we'd never done this. So it's unprecedented at a moral level, at a legal level, and it's very interesting for that. But I just want to note how unprecedented this was at a bureaucratic level. We all understand how big organizations work. We know that big organizations tend to want to do things they know how to do, for which they built a capacity. This is a situation in which the CIA was given authority to do something it did not know how to do. It had never done. It had no in-house capacity to conduct these interrogations, no particular expertise in having to do so. So just as a bureaucrat, the notion that an organization would be so entrepreneurial, so innovative, so daring, so radical in devising an entirely novel program unknown in the practice of the United States, in an agency that had no institutional capacity to carry it out, and do so in incredibly compartmented circumstances requiring enormous investments of the personal time of the director of the CIA and his top deputies, in addition to other top leaders of the United States. I mean, simply as a matter of how the U.S. government made such an unorthodox decision, that puzzles me as well. So first, we need to set the scene. In setting the scene, I just want to recall, first of all, the great fear and anxiety that enveloped the leadership of the country in the days, weeks, and months after 9/11. My essay goes into this in a lot of detail. I just simply want to sort of note it for the record, and I think this would be an agreed finding of fact, that the leadership of the country in those 6 months was profoundly anxious about the danger of further terrorist attacks and felt that anxiety in a very personal way. Next, it's important to note the role of particular institutions and personalities in making these decisions. And what I want to call out, first of all, is the unusual role played by the Vice President and the Office of the Vice President. Even before 9/11, the Vice President had taken on particular responsibilities for looking after the intelligence community on behalf of the President. After 9/11, those responsibilities intensified, partly too because the Vice President is a constitutional officer who can also look after domestic intelligence issues as well as foreign ones, which some of the National Security Council staff, like Condi Rice, do not naturally do. So that gave the Vice President some unique advantages in overseeing this part of the intelligence establishment. The best way to understand the setup after 9/11 and for the months after that is to think of, we're now fighting a war. The war has a combatant commander. The combatant commander, the general Petraeus, so to speak, to think of for this war was George Tenet, the director of the CIA. He held command meetings on the 7th floor of the CIA headquarters in Langley every day at 5 p.m. If Tenet was the combatant commander in the war, the Secretary of Defense for that combatant commander was Dick Cheney. If you understand it in that way, the role begins to make more sense. Cheney and Tenet were very close during these months. They would later grow more distant from each other, but during this period it's important to understand how closely they were working together. In addition to Cheney himself, it's also important to call out the role of his counselor and legal advisor, a man named David Addington. Addington is a singular figure, deeply experienced in national security law, deeply experienced with profound convictions about them, who approached these sort of issues with an ascetic, Jesuitical fervor. In addition to those two personalities and their role, which are distinctive, it's important to call out the significance of the CIA, its primary role in this period in running this war, and then a couple of key personalities in CIA, which are also distinctive. The personality of George Tenet, that passionate and impulsive person, man who I think would have made an absolutely outstanding director of operations for the CIA, but who was stressed in taking on all the roles of running that agency on both the analytical and the operational side. And then, as his key chief in running counterterrorist operations during this period, Cofer Black, personality not nearly as well known as names like Tenet or Addington or Cheney, but someone who I think is at least as important as those other three in devising these policies. Cofer Black is a veteran of the Directorate of Operations. He is an outsized theatrical personality. It's easy to find some clips of him maybe where you could watch his testimony before the 9/11 Commission. If you watch him for 5 minutes, you have a sense of the man. Authors who've tried to capture him refer to his piratical bluster. What he was superb at doing is parlaying the mystique of the agent in the field to Washington audiences. Because people believe a lot of stuff about the world of the CIA, and Black knew exactly how to capture that and use it. But the key point for our purposes, he was entrepreneurial, and rather than someone who would be the calm check on Tenet's impulsiveness, he would be the person who would run with it. So having set the scene a little bit, let's just review the chronology. There are two big preludes before they get to these interrogation decisions, I think. In October of 2001, they made significant decisions about surveillance programs in the United States using signals intelligence capture that were pushing the bounds of the envelope of what was legally possible, were daring improvisations. In November of 2001, they began setting up military commissions to try possible enemy captives. What's noticeable about that is the whole process during which those decisions were made was essentially run by Vice President Cheney and circumvented the usual interagency process. After the November 2001 decisions, which totally blindsided even Condi Rice, Rice basically cried foul and said that we cannot run the interagency this way. Either Al Gonzalez resigns or I resign. And so the result was then that the subsequent decisions that had to do with interrogations were made in a different way, but not a way actually that brought them into the NSC policy process. So you have that little prelude. And then we come to two key waves of decisions on these issues of how to question enemy captives. The first of those were the decisions on what legal standard should we use. These were decisions made in January and February of 2002. Now, the chronology here is interesting and important to understand. If you were to read Dick Cheney's memoir, which was published earlier this year, he would tell you the standard story, which is if you kind of like the question, how did you devise these interrogation techniques? You'll find a couple of paragraphs in his memoir that will put it this way. We captured this guy, Abu Zubaydah, potential senior al-Qaeda chief, in March of 2002. We were desperate to find out what he knew. We devised extraordinary ways of questioning people to find out what we needed to find out to protect the country. So you would get a causal chain that looks like, we captured this guy, extraordinary urgent necessity, we devised extraordinary means. Except that I believe, and the evidence is bountiful for this, that the means to begin questioning people in these unusually and extreme ways were devised months before Abu Zubaydah was captured in December, January 2001, 2002. They had already been working this out. And that those methods were already entrained between CIA and the Department of Defense at a bureaucratic level as they were preparing the decisions on legal standards, which did not put the decisions on interrogation practices before the president. But I think the people who were writing up the proponents of the new legal standards already knew what kind of interrogation procedures they were probably going to be considering using. So when those decisions are made in January, February, as Jordan Powell commented in his introduction, they decide, first of all, of course, these people don't get full Geneva Convention prisoner of war status, formal POW status. Now, to a lot of you out there, it might seem, well, isn't that what the Geneva Convention is about? You either get POW status or you don't. And actually, I think the president and some of his senior advisors thought about it in very much this way. And the issue of whether you give them formal POW status is a pretty easy issue. You don't. The hard issue, the one that's buried down inside all these memos, the one that the legal experts instantly would have recognized as the key issue, is actually, well, what do you do for captives who don't get full Geneva protection? All the Geneva Conventions say, and have basically a floor that's put in the conventions for this purpose, that in conflicts not of an international character, you at least protect people against cruel, inhumane, and degrading treatment and arbitrary killing. So that this is what experts call the CID standard. It's codified in various forms, but including in all the Geneva Conventions. And all legal experts had understood that this was meant for the floor in those cases where you don't get all the formal POW protections. You at least kind of have this, this base protection that everybody's entitled to get. So the key decision that's made in January, February of '02 is that you do not even get this floor. We strip away the floor. That Common Article 3, which is this part of the four Geneva Conventions of 1949, conventions, by the way, sponsored and led by the United States, that Common Article 3 does not apply. Now, their argument was basically, well, gee, that says conflict not of an international character, and this is clearly an international conflict because we're going in another country, so end of story. Now, this turns out to be a legal error on two levels. It's important to understand both levels. Level one of the legal error is this. This is my view, and you can have an argument about it, but I think that it's a legal error for three reasons. First, there is a federal statute, not an international treaty, that was in force at the time that bans war crimes and makes war crimes a felony punishable by up to life imprisonment. Violation of Common Article 3 of the Geneva Convention was a per se war crime and felony under this federal criminal law in Title 18. So, in that law, it says that the crime consists of conduct constituting a violation of Common Article 3, which clearly points to the underlying conduct rather than the particular jurisdictional circumstances in which it's committed. Second problem is the words conflict not of international character aren't necessarily interpreted in a geographic way. In other words, the people who wrote the treaty thought of international as the same thing as interstate. They were writing this, against issues like the treatment of resistance fighters in France and Yugoslavia and places like that. And so they were writing for the circumstances in which a state is fighting something that's not a state, that's not a nation, and therefore it's not a traditional international war. Well, whatever Al-Qaeda is, it ain't a nation state. It ain't a nation. So a fight with Al-Qaeda is not an international war in that legal sense of the term. And, then you can argue, well, is it a geographic term? Is it a legal term? But there's pretty good evidence for the other side of the argument. Third problem is that this part of the Geneva Conventions had really become a peremptory norm of international law, widely recognized as such and considered binding, including by the United States and its lawyers for a number of years, so that even beyond the literal language of the treaty, this was considered to be a norm we had to obey. So I can make my argument that they made a legal error, and then their lawyers on the other side would say, well, no, we didn't, and here's our argument. And then judges, you could weigh that. So at the first level of the legal error, I'm making my argument, and then you can reject or accept it. Now, here's the second level of the legal error, though, and here's the one from which all of you should learn. If you were advising your client about a situation like this, you'd say, well, we have a legal argument that says this doesn't apply. There are some pretty powerful legal arguments on the other side. Maybe we can prevail, maybe we won't. But what you'd want to do for your client is basically say, this is actually kind of a close call here. The level 2 of the argument is that the client might say, well, what's my exposure if we lose the legal argument? Well, you have to answer the exposure is that you're committing a felony. And then think about what advice you'd give to your client. Close call, if the judge rules against you, you could go to prison for up to life. Well, you know, your client might be cautious. So the legal error part 2 is, I see no evidence the president was advised just how thin the legal ice was on which he was being invited to skate. The decision that's then made about the legal standard that puts this before the president goes through a process that's not run by Condi Rice, it's run by Al Gonzalez, because it's considered a legal issue. And so the White House counsel is going to run a lawyer's process that then ultimately brought a lawyer's issue to the president. And you know, the funny thing about the outcome of this, and I provide some evidence for this in my essay, is I actually think at the time they made the decision, Colin Powell and Condi Rice thought they had won an argument. They thought they'd actually beaten back the hardliners by winning Geneva coverage for the Taliban captives. If you look at the way the original proposal and the way it was changed before it finally emerged, and then the way Ari Fleischer promoted it when he rolled it out, I actually think that they thought that they had actually beaten back the hardliners, when in fact I think the hardliners had actually won the whole ball game, because they got the Common Article 3 thing eviscerated in ways that I think folks that fully didn't understand the significance of it. The next big phase of this decision was the intelligence decision made to actually execute the interrogation methods. Now, you can have a long discussion of why that decision made and why it was wrong. The discussion about why it was wrong on a policy level has to be made looking at, first, the information available to them in early '02. In early '02, they didn't know whether these questioning methods would work. What they could and should have known was that the United States had a lot of past practices on how to question enemy captives. There was a lot of British, French, and Israeli experience on this. And the bottom line from that experience is you may not want to go there. The intelligence value, actually there are interesting arguments on both sides. Among the Israelis, you can actually find directors of Shin Bet who are on both sides of this argument, who have a lot of empirical experience with these interrogation procedures. But bottom line is, by 1999, the Israeli Supreme Court, after agonizing debate, had effectively ruled out extreme interrogation methods even in Israeli jails. By 1999, after a prolonged Israeli debate about these issues, in which they'd sorted this out, and all the British and French cases are even more cautionary than that, none of this experience was apparently canvassed and inventoried for the president. Now, in their defenses, they say, well, look at all the things we've discovered since we began using these procedures that show how well they worked. And then they cite these various examples. Some of the examples are demonstrably false. Some of them may have ingredients of truth, but they're a little misleading, because what happens in intelligence work is you compose a mosaic of clues that might have 100 pebbles in it. And of course, the person who contributes each one of the pebbles thinks he's made the work of art. And then there's also the issue of, could you have gotten the pebbles some other way without using the coercion? And so in addition to that kind of post-hoc vindication argument, there are two post-hoc arguments that actually work the other way. Number one is, we ran a natural double-blind experiment against al-Qaeda in Iraq, where we actually, by 2005, were questioning people using without using the extreme coercive techniques against very hardened guys. And we broke al-Qaeda in Iraq without this. And in my presence, the president was told in the middle of 2005 that what we were doing against al-Qaeda in Iraq without using coercive interrogation was entirely effective. The President was told that by the commander of JSOC. We didn't mean to run a natural double-blind experiment using but we did. And it actually that experiment had provided empirical evidence by 2005. The second is look at the experience of the last 5 years. When we've gotten away from using these interrogation methods, we've completed breaking up al-Qaeda in Iraq, not entirely, but almost entirely. And we've had a great deal of success against al-Qaeda Central without using these methods. But the interesting thing that I wanted to focus on for a moment is why this decision was made. Partly there was an issue of process, but the process issue was not a policy issue. It was considered an intelligence collection issue. And it was brought forward on an entrepreneurial way by George Tenet, who told the President, this is uniquely necessary. My experts tell me it's uniquely necessary and we can do it. And, oh, Mr. President, you know you've already decided that this is legal 3 months ago. And so the response of that of Condi Rice and Colin Powell is, well, let's get something from the Attorney General of the United States saying it's legal. And the Attorney General then said it's legal. So you have the CIA director telling you it's vitally necessary and nothing else will do it, with no one in a position to contradict him. You have the Attorney General saying it's legal, and the President feeling a responsibility to protect the country. Now, again, I'm just trying to make these decisions understandable. But one of the things that's striking is that no one does a policy analysis of all the pros and cons of this. But then again, the CIA operators don't do policy analyses of intelligence collection methods when they propose them to the President. It would have been bureaucratically unusual for them to do that. Bureaucrats like Condi Rice perhaps should have insisted that it be done, and they didn't. But I simply want to understand the context of the way these decisions were made as a way of understanding what happened. There were then a huge series of battles when all these decisions got reevaluated, and when I was in government in 2005 and 2006. I participated in these battles, and the only puzzling thing I want to call out about all of that, which I recount in detail in the essay, is that even after we persuaded the government and the McCain Amendment was passed so that the CID standard was imposed at the end of 2005, the internal decision was made under great pressure from Condi Rice and others to impose the CID standard on everybody at the beginning of December. A few weeks later, the McCain Amendment passed. The remarkable thing was that the Justice Department and everybody else in the government, except the State Department, continued to maintain that the CIA could question people in this way without violating the CID standard. That was the argument that, in my view, jumped the shark. Because that argument turned actually on the way cruel, inhuman, and degrading were interpreted, which is interpreted in light of the way the same terms are interpreted in American constitutional law, which would mean that any county sheriff could waterboard people and conduct all these interrogation methods in a county jail in America, and it would not violate the U.S. Constitution. And if any of you who've studied constitutional law think that's true, then you missed a class in law school. The final point, I'll spend much less time on, and then perhaps I can come back to it if folks are interested, is to spend a minute or two on who are the enemy soldiers on this other set of issues. The definition of enemy combatants comes from the authorizations for the use of military force that came from both the Congress and the President in the fall of 2001. Basically, al-Qaeda and its allies who carried out the attacks on the United States were declared enemies of the United States, and we went to war against them. My concern, as I got to these issues later, is that we were interpreting the term enemy combatant as basically anybody who might be giving some material support to al-Qaeda-related organizations. So grandma at the cook pot, somebody who gives a donation to a suspicious charity, all might be enemy combatants. And these issues arise in a litigation known as the Boumediene litigation. And the important thing about this is, and these were people who hadn't been actually involved in combat, and it wasn't even clear they were members, full members of al-Qaeda, but they were in Guantanamo. 2 points stood out for me about this. One is when we define enemy combatant, the federal courts tend to see these as Guantanamo habeas cases. I had seen these cases as, this is a standard we use to decide whether to kill people, not whether to put them in jail. We use this standard every week in the field. I've been involved personally in some of these decisions. There is a high moral and legal burden you assume when you decide whether or not to kill people, you know, from death from above. And when you make those decisions, you can't just kind of decide that, well, anybody, you know, the banker in Switzerland, the professor in Florida, grandma at the cookpot. And we don't actually make the decisions in that way. There's really should be a two-pronged test. Are you functionally a member of the enemy organization, Al-Qaeda? It is kind of, are you a soldier in their army, so to speak, in terms that they themselves understood? Do they understand these people to be part of the organization with which we were at war? And is this individual engaged in active hostilities against the United States? That is either a combat role or a combat support role. So from that point of view, actually, we were applying the term enemy combatant in an overbroad way, and the federal courts have effectively held that we were and have condensed the definition of this, and the Obama administration has ratified that, and that's healthy and important. What you then get to is if they're outside the authorization for the use of military force, we can still hit people, but under a standard of pure self-defense. This is someone who's about to launch an imminent attack against the United States, and we can stop them with any means necessary, even if we don't have a formal congressional declaration of war. Now, the Al-Awlaki case, where we killed this American citizen, I think is not a very hard case. Al-Awlaki had been involved, I think, even perhaps in the planning of the 9/11 attacks, and certainly in planning of other attacks against the United States as a member of Al-Qaeda. American citizens can be enemy soldiers. In fact, one of the German saboteurs we electrocuted in 1942 was a dual citizen. So that was, the Al-Awlaki killing troubled me not at all. And I don't think you need to get into a Fifth Amendment due process analysis for a case like this at all. The lingering questions, though, that should stick with us about the definition of the enemy are three. One, are we going to continue to conduct a Twilight War beyond the scope of the original authorization for the use of military force? In other words, are we at war against a bunch of other organizations that we didn't declare war against in 2001 as Al-Qaeda begins to disintegrate? Are we at war with Al-Shabaab in Somalia, for example, or other entities? Second, if we're at war with particular individuals rather than organizations, how much do we still need to use war and the methods of war to go ahead and continue to conduct this? Kind of in a way, it's asking yourself, at what point exactly does this war end? Every war must end, sometime, somehow. And then a final point is that if we are at war, I want to stress the significance of restoring the primacy of using the military to conduct military operations. The operation against bin Laden earlier this year was an excellent example of a blending of primarily military means supported by lots of intelligence and CIA efforts. This is important because even under the law of war, civilians who are not part of your armed forces are not authorized under the law of war to carry out military killings of people. And they do not have legal protections when they do that. So I think for a lot of reasons it's important to kind of get the military back at the center of the conduct of essentially military operations. And let me stop there.
Thank you, Professor Paust. And I want to thank Dean Nimmer and the excellent and extremely impressive students of the Houston Law Review who've made it possible for me to come here from the West Bank, actually, a very long trip. I'm honored to be here. And I should say, first of all, that I labor under the perhaps disadvantage, I like to think advantage of not being a lawyer. And I'm going to try to make that clear. And I'd also say that one of the disadvantages about speaking third is that you have these two very smart people coming up before you who get to say all the really intelligent stuff. And I agree with much of what we have heard this morning. And I am going to position myself carefully politically, in a sense, between the last two speakers and say that I think the conduct we're talking about was indeed manifestly illegal, and I think there's a lot of evidence for it. I also think it was a policy mistake, a very severe one, and that if those involved had followed the way policy is supposed to be made within the American government, that it wouldn't have happened, and that those who indeed designed this policy knew that. And finally, I'd like to say that simply saying it's illegal is, unfortunately, during time of war, and we know this through history, not enough. Because times of war are the very times when governments do things that are defined in peacetime as illegal. I've called them in other places states of exception. It's a term, of course, from Carl Schmitt, but it defines a time when normal legal standards don't apply. So I think we have to look not only at law, but we have to look at policy and how this happened. And I think Phil Zelikow is uniquely positioned to understand how these processes work within the government, as both a professor of history, a lawyer, and a practitioner, a very distinguished one, has done a great service in giving us a minute analysis, which he sketched out here, but which is put forward in more detail in his paper, of how this came about. He said, and I want to emphasize that this was a momentous decision, historic decision. Not simply because of the laws against it, not simply because of the Geneva Convention, the Convention Against Torture and all the rest, but because the American Republic has defined itself, back to George Washington, Abraham Lincoln, and others, as a country that doesn't do this. General Washington intervened personally during the Battle of Trenton to protect Hessian prisoners from abuse, and he did it with an eloquent admonition for why. Abraham Lincoln, during the Civil War, said, and I can't help but quote this, that military necessity, now this is a cataclysmic war during which the future, indeed the survival of the nation, is at stake. Lincoln said military necessity does not admit of cruelty. That is the infliction of suffering for the sake of suffering or revenge, or for wounding, nor torture to extort confessions. And it's interesting that that phrase, military necessity, was taken by George Bush and turned on its head. He said prisoners should be treated humanely and to the extent appropriate and consistent with military necessity shall be treated in a manner consistent with the principles of Geneva. So you have Lincoln, an absolute admonition, an absolute commandment against cruel treatment. Bush using the same phrase as an enormous loophole. Now, why is this? Why was this so important to these earlier presidents? I think the answer to that is because the government was created, our country, our government, during the Enlightenment. It was thought of by the framers as being a model of a limited government of the future. And torture is almost a test case, a limiting case of what a limited government is not. Torture is when a state reaches through the skin of a person and seizes hold of that person's nervous system and uses his nervous system against him. That is what happens here, what happened here. In Guantanamo, we have a record of the 50-day interrogation of Mr. Katani, the 20th hijacker, some quotes from the Army's record. Detainee began to cry, visibly shaken, very emotional. Detainee cried, disturbed. Detainee began to cry. Detainee butted Sergeant R in the eye. Detainee bit the IV tube completely in two, started moaning, uncomfortable, moaning, turned his head from left to right, began crying hard spontaneously, crying and praying, began to cry, and so on. This goes on for pages. We know the specific, very much the specific things that were done to Abu Zubaydah: beating, confinement in a small box, very small box, which made his wounds bleed. We have fairly extensive accounts of it. I was dragged from the small box, unable to walk properly, secured to a hospital bed with belts. A black cloth was placed over my face. The interrogator used a mineral bottle to pour water on the cloth so I couldn't breathe. After a few minutes, the cloth was removed, the bed was rotated in an upright position, The pressure of the straps on my wounds was very painful. I vomited. The bed was lowered again. Water poured on again. Vomited again. I struggled against the straps, trying to breathe, but it was hopeless. I thought I was going to die. I lost control of my urine. Since then, I still lose control of my urine when under stress. And we have pages and pages and pages and pages of accounts of what was done in the most grotesque and repugnant way. And the one thing that is not special about these accounts is they're not new. You can read about them from the French in Algeria. You can read about them from the Argentines during their dirty war. You can read about them from the Salvadorans during the 80s and their dirty war. You can actually go into Phnom Penh at Tuol Sang prison, S21 as it's called, where tens of thousands of people were killed. See this beautiful picture of waterboarding. The only difference is, looks just like Abu Zubaydah describes it. The only difference is they used a can. I guess they didn't have mineral water bottles. Pouring water on their face. My favorite description is a wet cloth is laid over the detainee's mouth and nostrils, small stream of water constantly descending upon it. He sucks ye cloth into his throat and puts ye unhappy wretch into the agonies of death. That is a contemporary description of waterboarding during the Spanish Inquisition. Now, the Red Cross had no problem saying quite simply and directly that these detainees were subject, while held in the CIA program, either singly or in combination, the procedures constituted torture. It's absolutely emphatic. This was a secret conclusion given to the CIA by lawyers whose job it is, conferred by Geneva, to make judgments of these cases. When you read John Yu's treatment of this procedure, he, of course, does not mention any of these precedents. He also doesn't talk about the James Parker case, 1983, here in Texas, actually, when Sheriff Parker was prosecuted for waterboarding prisoners by the Reagan administration. Doesn't talk about the Yukio Osano case, Tokyo 1947, during the Tokyo trials, or the waterboarding, court-martials for waterboarding of Filipino prisoners in 1902. None of that is considered, and CID, of course, as Phil has told us, was not considered either, because that was taken off the table. And indeed, we know Alberto Mora, who's one of the few figures who comes out of this, who was the Navy Council, made a blunt judgment that CID was taken off the table here to make way for cruelty. And that, I guess, is the heart of what is distinct about my judgment of these matters, as opposed to Phil Zelikow's, which is that though he gives us a rather brilliant analysis, and you just heard it, of what the president did, what he was presented with at a given moment. The legal standards had already been decided. Abu Zubaydah was captured. The methods had been developed. The president is sitting there. The DCI comes in, George Tenet, and says, we've got this guy. He's not giving us the information we need. Here is the method. We've got it, Mr. President, and it's legal. So what was the president to do? Well, he approved. Or he said, as he says, Mr. Bush in his memoir, he said, damn right, go ahead and do it. So what could he do? So in fact, there's a kind of scandal foretold, or at least action foretold here, that everything is predetermined before the event, and his freedom actually is a bit of illusion. I think this is accurate. I think line by line it is truthful. I think the analysis is rather brilliant and brilliantly stated, but I think at the end of the day, it's not right. It's not right. Because when we look at this policy, the overwhelming evidence suggests that a group of people, a very small group, led by the vice president, and you heard the other members of this group enumerated by Phil Zelikow, sat down and decided that the country needed this policy, needed these techniques to keep itself safe after September 11th, and set about developing them. We have a lot of holes in what we know about how they were developed. We know about certain meetings. We know about the Council of the Defense Department, Mr. Haynes, asking for procedures. We have bits and pieces of this. A lot of the story isn't there. But I think there is enough of it to know that this was intended, and that taking CID, cruel, inhuman, and degrading treatment off the table was part of the plan for making this stuff possible. Douglas Feith actually admitted this in Philippe Sand's book, Torture Team, an excellent book about this, in which he said, yeah, this is what this was about. Of course, we were trying to strip protections from prisoners at Geneva. Now, to appreciate how damaging this is, I think you have to read some of the accounts of what actually was done. One of them I recommend to you, that I'll quote a couple of words from, is by Ali Soufan, who is the FBI interrogator, the most experienced person within the government in interrogating al-Qaeda prisoners. And he gives an account of interrogating Abu Zubaydah, during which, early on, he extracts from him the two pieces of information we know that were valuable and that were gotten from Abu Zubaydah, one of which was the identity of Mr. Padilla, the other was the nickname of Khalid Sheikh Mohammed. And at a certain point, a CIA team comes, he calls the leader of it, a contractor, Boris, and Boris tells him that he's going to try a different way. And what is Boris's theory? Well, he's going to force Abu Zubaydah into submission. His idea was to make Abu Zubaydah see his interrogator as a god who controls his suffering. Soufan, who's been doing this for years, asks a few questions. Have you ever questioned an Islamic terrorist before? He asked Boris. No. Have you ever conducted an interrogation? No. But I know human nature, he says. Now, reading this account, and I've given you just a little bit, you realize how much and how severely the decision to use these things hurt the country. And I'm not talking about some airy-fairy liberal idea about the, what it is that we are as a country and so on, or even our history. I'm talking about on a practical level of actually interrogating detainees. And, Phil alluded to this. There's a debate about the value of these techniques. That's absolutely true. It's true you can talk to Shin Bet directors, some of whom are for them, some of whom are against them. But I think we can set out a standard here that's fairly simple. One is, do these techniques extract information that could not be gotten by more traditional and, in fact, legal methods? The jury is very much out on that, and at least the public information available, including a study of U.S. history, and the methods, the program, for example, the very successful one that was used during World War II, and also what was done in Iraq, suggests that the answer to that is no, that these methods do not get you anything that you couldn't be gotten in any other way. But the second question is, assuming it does, assuming it gets you stuff you couldn't get in other ways, is this stuff valuable enough to outweigh the enormous costs these techniques carry with them? And there, I think we get back to the policy process. After 9/11, in a sense, the government, the main decision-making mechanism of the government was essentially, and I think purposely, deformed. The National Security Council system was bypassed in favor of a small group led by the vice president. They wanted quick action. They wanted bold action. The emotions that they were drawing on were anxiety, guilt, I think, about the attack, and the absolute determination to do what is necessary to protect the country, to do anything that's necessary. But sometimes doing anything that's necessary is not the right thing to do. And I think one of the problems you get when you have a tiny group like this essentially acting outside the government, circumventing all that the government knows about history, about policy, and so on, is you get a reflection of the individual blind spots, the individual shortcomings, the individual prejudices, being in fact inscribed in the policy of the United States. One of the most obvious blind spots of Dick Cheney, who's obviously an immensely experienced man, brilliant in manipulating the government, making the government work, vast knowledge of how the government works and of national security. One of his blind spots, it's become very clear by his public statements and private ones that we know about too, is that he essentially does not acknowledge the political character of the war on terror. He doesn't acknowledge what al-Qaeda is up to. He thinks they're basically about killing Americans, not about creating large events to build a movement, to build a political movement, to recruit people, to persuade people in the Muslim world to join the movement, overthrow their governments, set up a caliphate. And that these terrorist acts are about that. They're recruiting posters. This, I think, blindness to the political character of the war caused the United States to, in effect, make huge blunders, two huge strategic blunders. One was the invasion of Iraq, invasion and occupation of Iraq, and the other was setting up these programs and creating, in Abu Ghraib and Guantanamo in particular, a propaganda extravaganza which led to a revivification of al-Qaeda as a political movement and as a military movement. And I think you have to be in the Middle East, or you don't have to be, but it helps to be in the Middle East, to travel in the Middle East, to look at the murals of Abu Ghraib images, to talk to people about their idea of the United States, to know how absolutely gravely important these decisions were in affirming to Muslims, especially young Muslim men, that the image of the United States put forward by Osama bin Laden, that the U.S. is a superpower intent on humiliating, oppressing, repressing, and abusing Muslims, and it must be attacked. To see how this image was affirmed by the United States itself, by what it did after 9/11. And I think if the policymaking process that was set up after World War II, the National Security Act of 1947, was followed, which was set up after all at a time of nuclear danger, the time of the Cold War, if it was followed, this would not have happened. The country would not have been severely damaged in the way it was, and we all would not have been left with torture that is no longer, in effect, illegal. It used to be anathema and illegal. It's now a policy choice. That's where we are. I leave it to the young law students after us to work that out. Thank you very much.
As I was listening to these remarks, I was trying to figure out how a lot of you were kind of taking all this in. Of course, you're all practicing law mainly in Texas. You're going to go back to your business. Probably none of you are going to be involved in making war on terror legal decisions in your jobs. And so since you're getting continuing legal education credit for this, I thought it was just kind of worth reflecting a little bit. How do you relate the significance of this story to the work you do as attorneys, the kind of issues that you confront? And so I wanted to offer you just a few comments on that. You've heard these presentations. I actually agree with most, if not practically all, of what David and Mark said. We've been emphasizing some different points. Of course, it's possible you can take the point of view that these things are necessary when the country's threatened, and we only tormented a few people, and they were bad people anyway, and not accept any of the premises of this. I happen to agree, actually, with Mark's point, and actually Secretary Rice agreed. By the beginning of 2005, it was our considered view, and we told the President, that the cluster of issues that were referred to by the shorthand of Guantanamo or Abu Ghraib or torture were at that point hurting the United States in our foreign policy more than any other issue in the world, including the war in Iraq. It was doing more damage to us than the war in Iraq was doing. That's how serious we thought the issue was, at least by the beginning of 2005. This is just one way of estimating these matters. But when I was thinking about how to turn this story into something that might relate to issues that you'll encounter, I wanted to focus on three things. The first is this question of law versus policy. Think about the role the lawyers play in this story. In effect, an idea comes up, and the policymakers need someone to tell them whether or not it's okay to do it. And they turn to the lawyers to tell them whether or not it's okay. I mean, even in kind of the last case, you get this tenant comes in, Mr. President, this thing is necessary, and The way he frames it is as an intelligence collection procedure. CIA intel operators don't write policy and analysis papers. That's the kind of thing desk lawyers do, not what field guys do. What they do is they reach out, well, at least let's get the Attorney General to give us an opinion. And the role the Attorney General is playing here is he's a secular priest. He's granting absolution. He's telling them it's okay. Lawyers frequently are being called on more and more in our society, in which our moral vocabulary is increasingly impoverished, to basically play the role of providing a secular absolution, telling the client whether or not what they want to do is okay. And they'll read okay in a pretty broad way. My lawyer said it's okay. So, but notice the way the question actually goes to the lawyers is not a question of should you do this or shouldn't you do this. It's can you do this or can't you do this. It's a different kind of binary choice. The analysis you do is like, is there black letter law saying the client cannot do this? And they actually, the lawyers in this case, they looked and said, well, the black letter law is pretty damn gray, very murky. And so if I want to help my client and come up with a legal theory in this murky terrain about, well, there's a theory in which this can be done, a clever lawyer, and they had some clever lawyers, a clever lawyer can write such a theory. And they said, well, you know, in this theory it can be done. Now, and by the way, the lawyer isn't addressing the issue of should it be done. Is it wise? Is it prudent? Because that's not the question that was framed for the lawyer. It was, can it be done? And then you're in this murky legal terrain. Now, David would argue, and did argue, it's actually not that murky, that the legal issues actually were pretty clear-cut. And I have some sympathy for that argument. But I'm just observing the way the lawyers were played in this case is just very interesting. So the lawyers get an issue of can, can't, in which, lawyer, you're told that this is necessary to protect the country. Can I do this? Imagine you're the lawyer put in that position. And actually, as lawyers, you're often given questions that are faintly reminiscent of that. And just notice the position the lawyers are being put in. But notice, well, maybe there's some other process that does the should and should not piece of this. And observe that in this case, actually, the policy process was deliberately manipulated so that that wouldn't happen. I've got a legal standard in which I've gotten the absolution first. Then I come back at you later with an intelligence collection technique that the field says is necessary. So it's important to look at what the legal side of this is. David's argument is important. If there's a legal bar, there's a legal bar. But it's also important to notice the way lawyers are used in a case like this, where lawyers take on a role in the policy process that actually is disproportionately important, in which legal issues are confused with legal policy issues. All right, so second observation that might be relevant to you is notice the role of culture in this case. You know, a lot of times we have these dry legal arguments in a conference like this one or in a classroom, but of course when you're actually making these decisions and working with your client, you're in some particular corporate culture or business culture. You're in some situation where there's a social context. The color of the social context is very important here. So for example, in this case, you've got a culture in which we're under great stress and we need to be tough and we need to be decisive. By the way, Bush's advisors knew that the one way in which to help get your president to say yes to what you wanted to do was to tell him this is a hard decision. This is a president who waited on tough decisions the way a batter waits on pitched balls. That's part of a culture. Another part of the culture is what I'll call the culture of the field guy. And some of you will experience this in other ways in your daily lives. One of the extraordinary aspects of this set of decisions is the way during this period in which the tough, gritty world of the field worked its way into the consciousness of the nation's leaders to a degree rarely seen before or since. There's a large cultural divide that shadows these judgments that I want to bring to the surface here. A divide between the world of secretive, bearded operators in the field coming from their 3 a.m. meetings at safe houses, and the world of Washington policymakers sitting in their wood-paneled suites. Now, the policymakers sense this divide. And because they sense this divide, they often and naturally become more deferential, because they're conscious that I'm the suit sitting in the suite. And they especially become deferential in a time of seemingly endless alarms. What policymakers sometimes miss, and what the lawyers, of course, can miss too, is that the world of the field has many countries and many cultures of its own. It's actually often much more complicated than you may realize. Veteran field operators actually often disagree about what the government should do, and in this case, if you had actually went to the field, you'd have found that there were actually CIA operators all over the place and how they thought about this. But that's not the way it got represented back in Washington, and the policymakers didn't know it when they were being deferential to what the representative of the field guys was telling them. So that's an important cultural dimension to keep in mind. The CIA is an organization, for instance, with many, many cultures and factions, many of which are simply invisible to senior policymakers. Third and final point is the significance of bright line standards when you run an institution. And here I just want to reflect for a moment on what happened to the United States Army in all of this. The Army went through a fairly serious, agonizing period during the Vietnam War, climaxed by the My Lai massacre. If you study the history of this, you'll find that about 1970, the Army, ashamed and embarrassed by what its soldiers had done, made a concerted effort from 1970 forward to clean up, tighten up, and make sure standards were enforced. Basically, their people had been in a regular conflict. It was a blurry world. Bad things had happened, foreseeably. And the Army made a real effort, 1970 forward, and this carries forward for a whole generation of JAG lawyers and others in the Army until really 2002. And in 2002, they're given a whole bunch of blurry standards. The blurry standards actually are partly enacted for the benefit of the CIA program. They have to adopt a legal position to handle a handful of people in the CIA program, but that means that the legal guidance and the body language from above that's given to everybody else is equally uncertain and confused. The result of that goes on a much larger scale, because what happens, of course, is you then give fairly blurry guidance and uneven body language to hundreds, sometimes thousands of young people in conditions of extreme stress and violent power. And you all know, as managers of organizations, exactly what to expect when that happens. You don't know where the abuses are going to happen, but you know they're going to happen. In other words, there was going to be Abu Ghraibs. Whether and when and how that happened, there were going to be soldiers who started taking war trophies. I mean, all that stuff is going to start happening. Because one of the things that you learn in running large organizations is if you put people in situations of high stress, you need to train them rigorously to get ready for that, and you need to train them on bright line standards that give them guidance that they can use in making split-second decisions. Or at least very quick decisions of 20-year-olds under extreme stress. And therefore, you need bright line standards. And when you confuse the guidance, that confusion and nuance may work really well in a legal memo in Washington, but translated into the field and implemented by large organizations, disasters become foreseeable. And I think that's guidance that all of us can take away for our professional work.